Hi and welcome to this immigration law update video. In these videos, what I've tried to do is give you a quick summary of some recent case law, policy and statutory developments. If you're interested in a more detailed look at some of these matters, sign up to one of my seminars through organisations such as HJT Training, MBL Seminars, and the Solicitors Group, all of whom I've got upcoming seminars with giving full updates on the recent developments in immigration law. In this video, I'm going to look at the latest decision concerning Zambrano carers. This is an important area of EU law where people can obtain a derivative right of residence where they're a primary carer for, in this case, a British citizen. In the past, derivative rights of residence have not led to a permanent right of residence, but under the post-Brexit EU settlement scheme, they can lead to settled status. So Zambrano carers' rights have been somewhat enhanced under the EU settlement scheme, and this issue therefore has an enduring relevance. And the case I'm going to look at today is a recent decision from the Supreme Court called Patel and the Secretary of State. It's 2019 UKSC 59, and it comes from the 16th of December 2019. And it concerned two linked cases. The case of Patel. Mr. Patel was an Indian national and he cared for his adult British citizen parents. And then Mr. Shah, a Pakistani national, who cared for his British child son. Interesting, in the Shah case, Mrs. Shah was a British citizen, resided here, but worked full-time. And Mr. Shah had been accepted to be the primary carer of his son. In this case, the Supreme Court rely heavily on the decision of the Court of Justice from 2018, KA and Belgium, which is 2018 3 CMLR 28. And that case consolidated much of the case law in this area. And as I say, the Supreme Court rely heavily on it. And what lies at the heart of the Zambrano jurisprudence is whether the EU national would be compelled to leave the territory of the EU if the third country national carer was removed. So paragraph 22, let me read you what the Supreme Court says. It says this: what lies at the heart of the Zambrano jurisprudence is the requirement that the union citizen would be compelled to leave the union territory if the TCN, that's third country national, with whom the union citizen has a relationship of dependency, is removed. And in this case, the Supreme Court draw a distinction relying on KA between carers of adults and carers of children. Now, in the former case, in concerning adults, it's only in exceptional cases that a Zambrano case will be able to be successful and that a finding of compulsion can be made. And they look at the case of Chavez Vilés from the Court of Justice, and the Supreme Court say, well, look, this concerned children. Now, in children cases, the case is somewhat different because the best interests and the welfare of the child can be considered. So in the Shah case, that was successful. And the Supreme Court held that the Court of Appeal were wrong to consider that there wasn't compulsion because Mrs. Shah, the British citizen, had the choice to remain with the child and wouldn't be compelled to leave. Let's have a look at paragraph 30 of the judgment. Apologies for reading, but it's a good summary. The overarching question is whether the son would be compelled to leave by reason of his relationship of dependency with his father. In answering that question, the court is required to take into account, in inverted commas, in the best interest of the child concerned, of all the specific circumstances, including the age of the child's physical and emotional development, the extent of his emotional ties, both to the union citizen parent and to the third country national parent, and the risks which separation from the latter might entail for that child's equilibrium. I love that phrase. Go home and ask your child, how's your equilibrium, darling? That's a quote from Chavez Vilés, paragraph 71. The Supreme Court goes on to say, the test of compulsion is thus a practical test to be applied to the actual facts and not to a theoretical set of facts. As explained in paragraph 28 of this judgment on the FTT's findings, the son would be compelled to live with his father, who was the primary carer. That was sufficient compulsion for the purposes of the Zambrano test. There's an obvious difference between the situation of compulsion on the child and impermissible reliance on the right to respect for family life or on the desirability of keeping the family together as a ground for obtaining a derivative right of residence. Those are not the test. It's one of compulsion, remember. So the Supreme Court say it follows that the Court of Appeal was wrong in this case to bring the question of the mother's choice into the assessment of compulsion. So the takeaway summary is, in respect of Zambrano carers, there is this difference between adults looking for something exceptional to show compulsion and children, where all these factors such as the best interest, the relationship with the different parents come into play. But it's a real practical test and not these hypothetical about whether the child could stay with the other parent. I hope that's helpful.